Now is it visible? There is some problem. Now is it visible?
Yes, sir.
So I hope we can.
Hello, sir. Sorry to interrupt.
Yes.
Actually, in our campus, the entire Wi-Fi has just now it has started showing problem. Just give us three,
Okay.
4 minutes. Just
No,
give us
no
three, four
issue. No
minutes.
issue. No issue. No issue. No issue. If suppose it's not visible from my side, then you have to please help me in operating this PPT. Huh?
Yeah, that's what I am trying, sir. If I am, it is visible now, sir. It is visible.
Visible? No.
Yeah,
Okay.
yeah, it is visible.
Okay.
Sir, I'll be back. I'm just trying to reconnect for my network connection.
It's okay. No issue.
Krishna, are you here? Hello, Krishna. Participants are requested to keep little patience. Actually, suddenly the Wi-Fi got disconnected in our campus.
Good morning, sir. Am I audible, sir?
Yes, you're audible, but your voice is breaking.
Sir, please excuse me for the network issues here. Uh,
Okay, you continue. You can
Good
start the
morning.
session now.
Yes, sir. Good morning, everyone, all the participants and resource person who have joined us for the sixth day of the 7 day FDPR, FDP on IPR. Today with us we have Dr. R.K. Mishra, sir, Associate Professor, Department of Law, Northeastern Hill University. He will be discussing about IPR in the digital age and challenges with AI, blockchain, and digital assets. So, sir, it is indeed my pleasure to introduce you to all the participants here, sir. Mm, Myself, K.M. Krishna Shekhar Sharma. I take this opportunity to introduce Dr. Ravikant Mishra, sir. He is an associate professor in the Department of Law at Northeastern Hill University, Shillong since 2018, having joined as an assistant professor in 2005. He earned his PhD in Law and LLM from Banaras Hindu University and his LLB and BA from Lucknow University, where he also obtained a PG diploma in criminology. His research interests include intellectual property rights, traditional and indigenous knowledge, and criminal law. Dr. Mishra has published over 25 papers in peer-reviewed journals, contributed to more than 8 book chapters, and authored a book with an international publisher. He has guided one PhD scholar to completion with 4 currently registered and has supervised 11 LLM dissertations. Additionally, SAR has participated in over 20 national and international seminars and delivered numerous lectures as a keynote speaker. With this brief introduction, Sir Mishra sir, I welcome you on behalf of Department of Law and all the participants who have joined to attend your session today. Uh, Sir, as the session is for 2.5 hours, you have the discretion to take a small brief break in between after 1 hour, sir.
Okay, thank
Am
you,
I audible, sir?
Krishnaji. Thank you very much.
Yes, sir.
And good morning, friends who they are online and participants. Myself, R.K. Mishra, I have been introduced. Friends, today we are going to discuss about IPR in the digital age challenges with AI, blockchain, and digital assets. Before entering into the subject matter, friends, let me make few points clear to you all that this is going to be an informative session. As I was told that there is a vibrant uh, participation from several streams, so therefore I have tried to make it more simple, not very complex and technical in legal terms. And therefore, I would like and request you all to please keep an insight and focus on the points we are discussing, though many of the points I'm not going to touch in details, but it is obviously going to be very informative for all of you and an eye-opening what is happening in the area of intellectual property rights. As we all know, friends, that intellectual property rights are legal rights that protect creations of the human mind in the modern digital landscape. This presentation explores how traditional IPR concepts are being challenged by emerging technologies like AI and blockchain. We will delve into the insertion of intellectual property law with digital innovations and solutions. Now, what is IPR? What it protects? A general understanding, I hope you all are having. So, I will be just focusing few key points. Say, for example, intellectual property rights protect intangible assets created through human creativity and innovation, including inventions, literary works, artistic works, designs, symbols, and names, etc. As we all know, that there is an arena of intellectual property covered under various different areas. Say, for example, geographical indications, designs law, semiconductor and integrated circuits. So we had lots of areas where the intellectual creativity has not only been recognized but also has been protected. Now, how digital era is revolutionizing and impacting this intellectual property regime. The digital revolution has transformed how we create, distribute, and consume intellectual property, making traditional protection methods insufficient. Understanding IPR is crucial as our economy becomes increasingly digital and knowledge based. Now, what is happening in the modern era? With the help of technology, we are creating lots of things. And with the advent of AI, many of the things are nowadays being created by the machines. Now, how to recognize and how to protect, that is the biggest challenge before the legal fraternity. Now, how it is challenging? What is the traditional IPR? Traditional IPR was designed for physical goods and analog creations, where copying was difficult and distribution was limited by physical boundaries. Say, for example, publication of a book. Okay. A book was published in the publisher's house and then it was distributed physically, so there were limits. But when it comes to the digital IPR challenges, we all know it is nowadays very easy. Digital content can be perfectly copied infinitely at zero cost and distributed globally in seconds, creating new challenges for rights holders. The internet has created new forms of intellectual property that don't fit neatly into traditional categories requiring legal framework adaptation. As we all know, that the very nature of the legal system is municipal or local. Every country has its own law. But when it comes to the infringement or violation of the intellectual property, now with the digital technology, it has become global. And the law which we have is municipal or local in nature. So, how to handle this transboundary problem? Similarly, there are certain other challenges, say, for example, jurisdictional challenge. As I have told, when there is an issue between two nations or crossover problems, then which nation or which law will have jurisdiction is the biggest problem. Digital content can be instantly shared across borders, making jurisdiction and enforcement complex issues in IP protection. Because if content is created in India and through internet it is distributed somewhere in Western countries, then which law will be applicable? Jurisdictional issue is a big problem. Similarly, access of justice for the person who is affected by this infringement or violation is another biggest problem. Similarly, blurring lines between the two. Technologies like 3D printing allow physical items protected by IP to be replicated using digital files, blurring the lines between the physical and digital IP. So now physical IP can also be transformed into digital ID in 3D printings, and similar type of items can be produced in other jurisdictions. So that is another problem. The third issue before the law is enforcement difficulty. The anonymous nature of the internet makes it difficult to track infringers and enforce rights across different countries. As we all know that the nature of the law or the legal system is local. And when any infringement is done by a person sitting outside, then how to bring him within the bars of the law of your own country is the biggest problem. Now, AI and IPR overview. AI as creator and infringer. AI has the capability of creating things. Similarly, AI has capability of infringing the copyright of the copyright holders. Artificial intelligence can both create and infringe intellectual property, raising questions about ownership and liability. Now, how it happens? Friends, few years back, I think 2 or 3 years back, there was a abstract painting created by somebody. I just exactly don't remember his name. Somewhere in Bangalore or Karnataka itself. And the name of the AI, this algorithm he has given was Raghav. And then he has applied for the copyright protection for that abstract painting in ownership with that AI engine. And that has created a problem for the copyright office. Now, the question before the Copyright Office was whether AI is entitled and eligible under the existing copyright law to get copyright protection for the work created by AI as an owner or not. And if not, then what is the legal position? Now, here, I wish to make you all clear on this point that the law, when it was passed and made, it was made for the human creativity. And therefore, in any case, human intervention is required. Here also, algorithms are developed by a human. But the question before the law, whether the machine or the AI is entitled to get it or not. So the law does not have any answer. In our copyright law, there is no such provision which provides that the AI should get this chance or get this protection for its creation. Similarly, these type of traditional concepts which are in existing laws are being now challenged by the AI and AI created materials. Current IP law assume human creativity, as I have told, and decision making, but AI can autonomously generate content, inventions, and designs. The increasing sophistication of AI systems challenges traditional concepts of authorship, inventorship, and creativity in IP law. So now these are the challenges which are being posed. Now, what are the AI generated works? The first issue which comes up in our mind related with the AI created work and the existing legal system is the ownership complexity. When AI creates artwork, music, or literature, determining ownership becomes complex because multiple parties are involved. Say, for example, AI developer, the user, and the AI itself. Now, to whom this ownership should be vested, or it should be granted to all jointly. This is a big issue before the law. Similarly, current copyright laws require human creativity, making it unclear if AI generated works can be protected under existing framework, as I have given one example to you all. Now, the thing is that if there is an AI generated work, then the law which is in existence was made for the human creativity. But here is also is a complex issue that the AI itself is generated by human creativity. But afterwards, AI is enabled to take its own decisions. Friends, just a second.
जी सर हेलो बोला एक मिनट रुकना जी सर हेलो
Hmm.
सर वो आज की डेट का फोल्डर बना दिया पेन ड्राइव में
Sorry for interruption, friends. I hope you all will not mind. So, the third is artistic value and protection. Examples include AI generated paintings that have sold for thousands of dollars, raising questions about artistic value and copyright protection. Now, if any work is created by AI, then whether AI independently can be recognized as a owner of a work created by AI, or the person who has generated those or created those algorithms because of which AI is enabled to do it, that programmer should also be included. These are the questions before the law to decide. Now, AI as an inventor, in many cases, AI is working like an inventor. In many cases, like for example, patent offices worldwide are grappling with applications listing AI systems as inventor. And there is one case, the Abu's case, in which AI was listed as an inventor, and this was rejected in multiple jurisdictions. Whereas the applicants, they wanted that the AI should also be recognized and granted as patent as a co-owner, but it was rejected. Why? Because the patent system is not meant for the AI or the computer generated machines, it is meant for the humans. This is the biggest question. And as with the advent and development advancement, we are taking help of the machines, programs, and the AI generated AI enabled systems. Now, if we do not recognize AI work, then to whom should we grant? That is the biggest challenge before the law. Protection gap, this creates a gap in protection for AI generated inventions that meet all patentability criteria except human inventorship. Now, friends, there is a very famous case of Japan where uh, there was a lady patient, and that patient was provided treatment by the hospital in all possible ways known for the medical science by the hospital for a cancer patient. Now, afterwards, the doctors, they said that they don't have any medicine or any other way to treat her. And then, for experiment, an AI was used, and all information related with her treatment was given to the AI. And after analysis, the AI suggested a medicine along with the operating procedure for help of the patient. And although patient was not fully cured, but positive symptoms started after the suggestion given by the AI was applied. And after this example, many of the companies, they are trying to develop their own uh, AI systems for the medical cure and help. If these type of AI technologies are there and they are creating something new, then whether they should be granted patent protection or not is the biggest challenge before the law. Now, for the copyright, there are certain challenges like fair use and licensing. When it comes to the in concern with the AI, then ensuring the fair use of the existing copyrighted work or licensing procedure becomes very complex, because it's easy to infringe the use of any copyrighted material through the AI. Second, enabling AI to ensure whether copying of a particular work will fall within the category of fair use or not is another challenge. Similarly, licensing procedure, whether the AI is having a right to the conditions posed by the copyright holder to use a particular material as a licensee or not, that's another challenge. Similarly, text and data mining is also a biggest challenge before the copyright law when it comes in terms of the AI. Mimicry and infringement is another challenge when it comes to the artists, the performers, the broadcasters. Then this poses another challenge because it is easier through the AI to create mimicry of any of the existing work. Then how to train data rights, licensing and fair use concept, for that the new technologies can be used. I'll tell later on how it will work with the help of blockchain technology. Privacy challenges is another, privacy right is another threat which is posed by AI, whether the AI is interfering or AI is enabled to interfere in the rights of those copyright holders or the IPR holders, where they do not want to means expose something or to express something. There also AI can interfere in the existing work. And data rights management is another challenge before the legal system. Now, how this can be curbed? What technology can be used for ensuring or helping the systems? So this is the blockchain technology, a new era for IP management. As we all know, blockchain is a decentralized digital ledger system that records transactions across multiple computers in a way that makes the recorded information highly secure, transparent, and immutable. Blockchain technology can revolutionize IP management by automating licensing agreements, ensuring secure and transparent loyalty payments, and permanently recording ownership transfers. Now, friends, this technology works something like this, where these type of blockchains are created which are connected with each other but fully secure, and therefore when the information is stored in this chain, this chain is attached with the existing chain, and this is how it works. Now, blockchain technology basics. First, distributed ledger. Blockchain is a distributed ledger that creates permanent, unchangeable records of transactions and ownership. It can help in creation of smart contracts on blockchain, can automatically execute licensing agreements and royalty payments. As I have told you, when it comes to the fair use and licensing problems, blockchain technology can be one of the best options. Then proof of ownership, blockchain technology cannot be infringed or violated as per the existing knowledge. Tomorrow in future what may happen, I don't know. But as per existing knowledge and as per claims from the cyber experts, this cannot be violated. So this can be used as a proof of ownership. Who is the owner of that particular work? If it is a digital content. And for that, the technology provides transparent proof of creation, data, and ownership chain for intellectual property. Now, undisputable proof when it comes to blockchain. Till now, this is what is understanding about the blockchain technology and which is accepted. Blockchain timestamps offer a tamper-proof record of when IP was created. Every block on the blockchain is immutable, meaning it cannot be altered, providing irrefutable evidence for legal disputes. Now, IP right holders can register their ownership on the blockchain, creating a permanent and transparent record accessible to all. This fosters trust and transparency in IP transactions. Then there is another way of protecting copyright or intellectual property rights, ensuring in the digital age about the digital records and digital creation. This technology, which is called as non-fungible token or NFTs. NFTs are unique digital certificates proving ownership of a specific item. Each NFT is one of a kind and can't be exchanged like regular cryptocurrencies. NFTs verify authenticity like a digital signature for online assets. So NFT can be another alternative along with the blockchain. It is not alternative to the blockchain, but this is another alternative for the protecting intellectual property assets which are digitized in nature using this technology. So both the technologies have to be used, not only one. NFT is a new era of digital ownership. NFTs create a scarcity in the digital realm. Each NFT is unique and non-fungible, meaning it cannot be replaced or duplicated. NFTs enable the trading of digital collectibles, artworks, and other digital assets on marketplaces, fostering new markets and revenue streams. NFTs serve as digital certificates of ownership, providing variable and traceable proof of ownership for digital assets. So for digital assets, this can also be one of the alternative for protecting intellectual creativity, which is stored in the digital form. Understanding NFT ownership rights. While an NFT represents ownership of a digital asset, it does not automatically transfer copyright of the underlying work. Ownership rights are determined by the NFT's smart contract. So contracts like in blockchain contract, the NFT contracts are also created. Similarly, smart contracts are used to define the specific rights granted to NFT buyers. These contracts can include the rights to display, use, or resell the digital assets, but not necessarily the copyright. Navigating NFT legal challenges. Now, many NFTs are created without permission from copyright owners, raising legal issues around infringement of intellectual property rights. So, this is one of the biggest challenge before the law, that NFT created nowadays practically, but does not have permission from the owners. Similarly, NFT marketplaces face challenges in policing their platforms against infringing NFT listings, leading to potential legal consequences. Jurisdictional issues are also there. The sale of NFTs across borders creates jurisdictional challenges as different regions have varying laws regarding IP rights and digital assets. Now, these are two of the examples I have cited related to the NFTs, friends, which you can access on the internet. Now, virtual world IP. This is related, this is nowadays becoming a very serious issue, navigating the new frontiers. Valuable virtual assets. Now, virtual properties, avatars, and in game items can hold significant real world value requiring robust IP protection mechanisms. Ownership in a virtual world. Determining ownership of user created content within virtual games and platforms presents legal complexities. Now, multiple IP forms in gaming IP, protecting the building blocks. Games encompasses various IP types, including source code, game art, music, and storylines. Now, ownership rights surrounding user created content within games often remain unclear. When a user is playing a game and creating something, then for that, whether there is any protection under the IP law in existence or not, is a big challenge. Similarly, virtual items with real value. Virtual items such as in-game currency, weapons, and cosmetic items can be treated for real money. That is also one of the reality. Friends, one day my son, he was playing some game and he wanted to buy some weapon for this his online game, and he requested me to pay some money for that. Now I was surprised that when he is playing a game, and I hope you all might have experienced like this. Now these are the assets which are created during the game. But for that we are paying real money. We are trading in reality, whereas it is a game. So what is its position in the IP relations or intellectual property creations? That is unsure in modern legal arena. And for that, I remember one of the, I was, friends, just sorry, I was delivering a lecture in police academy for the newly recruited police officers. And there I was discussing about the criminal law, particularly about the offenses against women. And one of the participant, he asked me a very, you can say, surprising question. He asked me that, sir, if any crime is committed in metaverse, then which provision of the new criminal law will be applicable? I was surprised. Although I had a very small understanding about the metaverse concept, but I was surprised. Then I searched and I got news published in one of the Hindi newspapers from the northern India. And the news was about some metaverse incident happened somewhere in London city. That two of the players, one was the female, the other was the male, they were playing games online with their avatars. And in the game, the male avatar has raped the female avatar inside the game. And what happened? That has stopped the lady who she was playing through that avatar. And therefore, she has filed a case in the police station against that person. So nothing is in reality, nothing has happened. But she has suffered a mental loss, and the case was registered. Unfortunately, I didn't follow up that case, what happened later on. But this is where we are moving today. This is what we are going to experience in near future. Where physically a person is present in a room and nothing has happened with him. But virtually something has happened, and that may affect his mental condition or may ultimately result into some physical loss. So how to tackle these type of issues? Similar types of issues are being generated and created when it comes in terms of the intellectual property. So here, when we see related to the trademark, the domain names or the digital real estates are the biggest challenge nowadays. Domain names can conflict with existing trademarks, leading to potential legal disputes. Say, for example, there was a case filed in the court where a person was using a website's domain name Kabadi Bazaar, where he was using D for D, Kabadi, Kabadi Bazaar. And the other person has launched another website with Kabari Bazaar, Kabari. So only one word was replaced, D from R. And the claim by the person before the court was that the computers are used by the literate peoples. But practically, if you see, even whenever we used to type any website's name on the window, then immediately some suggestive names of the these websites comes in, and we used to click one of them. Hardly we used to type the entire address of the website. Similar was the situation. So that was a confusing type of domain name which was being deliberately used by that person so that the peoples may have access of his website, and that will ultimately be a big loss to the existing website. So these are the new domain name challenges which are being posed by the technology before the intellectual property law. Cyber squatting is another concept of the trademark law. Excuse me. And similarly, dispute resolution is another area for the concern in the intellectual property rights. Now then comes the next issue that is related with the cloud computing, IP in the digital cloud. The first issue which is related as a challenge before the intellectual property is cloud service providers raise questions about data ownership and the extent of their rights to use user data. Many of the companies, and we all know, whenever we want to log in into WhatsApp, then immediately it asks for the permissions. And we used to give several permissions. And these are the issues I think we all know through the news media. Everybody is aware about all these. But there are certain legal restrictions where they cannot use the personal data of the users. So that ownership is a biggest issue before the intellectual property law. Second is cloud providers require license to copy and process user data, striking a balance between user ownership and service functionality. Recently, you all might have heard there was a big discussion between government of India and a Starlink company of US led by Elon Musk, as we all know. And a few days back, there was a news that they may reach to some compromises. And the biggest issue before the company was that whatever user data will be collected by the company will be stored only in India. It will not be transported to US. So that's the biggest challenge, to retain the data and ensure the privacy of the users. Third is, users retain ownership of their data but must grant necessary license to cloud service providers. That is another issue raised by them. Now here, the biggest problem is raw data. Raw data itself isn't usually protected by copyright. But when it comes in terms of big data, then raw data is very useful. And if somebody analyzed that data and produced some result, extracting data from the big data, then who will hold intellectual property? That's a big issue. Similarly, analytical methods. Patents can protect novel analytical methods used to extract insights from data. So, who will do that? That will be done by the machines. Similarly, data compilations. Compilations of data can be protected by database rights, but not the data itself. So that's another challenge before the intellectual property, because we are living in a regime of big data. Now, Internet of Things. What is Internet of Things? Internet of Things refers to interconnected devices that collect, share, and process data via internet, enabling automation is smart decision making. For example, smart homes, wearables, etc. Now, how it is connected with the intellectual property? IoT innovations involve patented technologies, for example, sensors, communication protocols, etc., and copyrighted software driving device functionality. Now, whatever data is collected by these machines or these things, who will own that? They used to collect valuable data. Connected devices generate valuable data that can be analyzed for insights and business opportunities. Multiple parties, including device manufacturers, data aggregators, and users, may claim rights to IoT data, which is created by these supporting machines. And now, patents can protect innovative communication methods and protocols used in IoT devices. So these are the gray areas which are left out by the intellectual property till date. Similarly, digital trade secrets, protecting confidential information, strong security. Digital files containing trade secrets require robust security measures to prevent unauthorized access. Access control limits access to confidential information, ensuring that only authorized individuals can view or modify it. And employee monitoring measures help prevent data theft and misuse by employees. So these are the potential steps which can be taken. Now, digital enforcement, combating online infringement. Tracking infringement. Online infringement is challenging to track due to decentralized nature of the internet. Digital evidence must be properly preserved to be admissible in court. Friends, under the new criminal law system, digital evidence has now been accepted as available evidence and admissible in courts if it is protected and stored in a proper means in possession of the proper authority and proving with its hash value. So now the law is also developing gradually and accepting these digital evidences as admissible in the courts. Automated systems can help detect infringement by scanning for unauthorized copies of protected content. Now, the expanding realm of digital assets. Domain names, as we all know, domain names which represent online addresses are valuable digital assets protected by specific laws and regulations. In India, through the court pronouncements, it has now been accepted as part of trademark law. Similarly, social media accounts with their established followers and brand value have become significant digital assets subject to legal considerations. Online content, digital content, including articles, images, videos, and software, is subject to copyright protection and can be valuable digital assets. Cryptocurrencies and tokens representing digital currencies and units of value have emerged as new form of digital property requiring legal frameworks. Virtual items within games and the metaverse, including characters, clothing, and assets, have real world value requiring legal protection. So these are the digital assets. Now, software IP protection code and function. Software's code is protected under the copyright law, whereas many a times there was a huge demand from the software industry that software should be protected under the patent law. The basic understanding is about the codes and the characteristics of an invention. Due to these two conflicts, most of the jurisdictions they have protected code and source code items within the copyright law instead of patent law. Although there has been some examples where the software, if it is integrated and inseparable with the hardware, then it can get a patent protection. Otherwise, it is copyrightable subject matter. Now, database rights, data versus arrangement protects the creative arrangement of data within a database is copyrightable subject matter. Similarly, specific rights granted in some regions to protect databases from unauthorized copy. But data itself generally is not protected under the IP law. Data compilation is protected under the copyright law, as I have told you already. So that is another issue. Now, securing digital content and assets. Friends, if you all are agree, we can take few minutes break and then we can continue with our lecture. If in between any one of you wants to ask anything or had any query in your mind, you may please ask.
Sir, let me check the chat box.
Yes.
Sir, there is one question from Ramani. The term Raghava painting patent
Mhm.
might refer to a specific patent related to painting by an artist named Raghava. It's more likely that you are thinking about the interaction of AI, art, and intellectual property, particularly in the context of an AI tool called Raghav.
Hmm.
So this
No,
is the
I didn't understand it clearly.
event,
Because
sir.
this was not a patent issue. This was not a
Mhm.
patent issue. I just referred this example that AI Raghava has created a painting, abstract painting, and that painting was claimed as a copyright subject matter. But ultimately it was denied because Raghav does not, Raghav is an AI engine or AI machine, and Raghav is not a human. Copyright protects creativity of humans, not of machines. That was the issue. That is what I told.
Yes, sir. Might be there might have been some confusion, sir.
Hmm.
There is one another question.
Hmm.
Uh, she has given written something. Ma'am, you can unmute yourself and can refer your doubts. Okay, she has written like Ankit Sahani, an IP lawyer, owns the
Hmm.
Raghav app
Hmm.
and has been involved in the copyright
Hmm.
application for AI generated artwork created
Hmm.
using the tool. I think she is trying to clarify something, sir.
Yeah, yeah. No, it's okay. I just referred as an example. I didn't give any details about that. I just referred it as an example that if suppose any machine is creating any intellectual asset, then whether that machine is entitled to get intellectual property right under the existing laws or not. That was the issue. And that is what I made it clear, I think must be clear to all the participants, that the existing traditional legal system is meant for the human creativity, not otherwise. And therefore, we need to amend our laws or modify our laws. Existing laws does not recognize creativity of any tool, any engine, or any machine. Existing traditional laws are meant only for the creativity of the humans, and human intervention in any way is required. Now it depends upon the interpretation of the authorities from the offices or the courts ultimately. But the basic understanding about this is that the existing traditional legal system is meant for the human creativity. That is what I said.
Yes, sir. There is another different question
Yes.
asked by Ravikanta Sharma. Sir, what is the future potential of any work generated with the aid of technologies like AI, as it opined that infringement of copyright in most of the cases?
Yeah, that is what I suggested. And this is half of the presentation. I think let it be completed, then you will get your answer in the last. But even then, since you have asked, see, any work which is created with the help of technologies now is being, means, or you can say, is taken seriously in many ways. But till now, the legal systems are not ready to accept it in the way it is challenging today. Hopefully, tomorrow we will have the proper legal systems. We will have the amended laws or modified laws where these technologies will get recognition and these problems may be solved. So that is all in the future. We had very less examples today, very less demands today, but as we all know that law is not a static point of thing or a static thing, it is dynamic and it gets changes. So hopefully in future the legal system will accept these things, and necessary changes or modifications in the legal systems and existing laws will be made.
Yes, sir. I think we can take a few minutes of break. Then we can, at the end of the sessions, we can take the rest of the questions, sir.
Okay, thank you. Yes, please.
Yes, sir, we can continue.
Okay, so welcome once again, friends. Now, in continuation, securing digital content access and integrity. So the first is digital rights management controls access to digital content, limiting copying and distribution. This is necessary. The second option can be encryption, protects the digital content from unauthorized access and copying by transforming data into an unreadable format. And third is watermarking embeds invisible information within digital content, helping track its source and detect unauthorized distribution. So this is how the digital content or the digital assets can be secured with digital rights management, with encryption and watermarking. Now, social media and intellectual property. This is, I think, we all are using. So it is interesting for all of us to know. User license agreements. Social media platforms often require users to grant broad licenses to their content, potentially impacting ownership rights. Legal professionals must carefully review these agreements to ensure user IP is not inadvertently relinquished. So the first thing, as we all know, that whenever we log in into any or we open any social media account, we have to say yes or allow them to use our data. And fortunately or unfortunately, we all might have experienced that they used to pose long, long agreements, several pages agreements. Mostly, I think most of us does not read carefully the entire agreement. And another thing is also there that if we read that carefully, the entire agreement, most of the times we may not think of logging in to that social media account because lots of information and permissions they are asking. We may not be comfortable in providing all those informations related to us. But yes, practically what is happening, we used to give it. We used to allow every information. When something happens, then only we understand. See, friends, this data is used today by many companies, and this data is also a source of income. We receive several calls, several emails offering several types of products and many other things. I think we all have experienced this. How our phone number, our mobile number is reaching to these parties with whom we do not have any direct or indirect contact. That is a serious issue. So that is where the legal professionals have to check these legal agreements carefully. Similarly, they should make the peoples aware about these agreements. Sharing features and copyright. Social media sharing features like retweets or reposts can raise copyright infringement concerns. Understanding the legal implications of these features is vital for both users and platform providers. So here we are talking about the intellectual assets, but retweeting, reposting these materials or sending or forwarding to others now has become the criminal law subject matter also under the new criminal laws. So every person has to look at these things carefully. Then terms of service and IP rights. Platforms Platform terms of service can significantly affect user IP rights. Lawyers must guide clients in navigating these terms in protecting their intellectual property interests. So these are some of the ways through which we can guide public with the help of legal experts. Now, virtual world and IP. Real world virtual properties such as land, building, and avatars can hold significant real world value. Understanding the legal framework for protecting these virtual assets is critical. Now, it is also posing a challenge, as I have given you one of the examples published in a newspaper. Similarly, protecting virtual items, avatars and virtual items require robust IP protection mechanisms. Lawyers need to advise clients on how to secure ownership and prevent infringement in this digital realm. In-game creations, user-created content within virtual world raises complex ownership questions. Clear IP guidelines are essential to prevent dispute between creators, players, and platform providers. So, friends, there was a Hollywood movie, although I will not discuss it in detail because I just forgot its name. But in the movie, the concept was something like this, that there were two players and they were actually game developers and working for one company. An entire story of the movie went on the virtual world. And finally, in the last scene, I myself, as a viewer of the movie, understood that when the avatar said to another avatar, who she was a female, that whatever I am saying to you and the way I am behaving with you inside this virtual world is actually the words of that programmer who has created me. And in real world, she did not like him. But when she was acting through her avatar inside the game, then her avatar, his avatar was liked by her. And she fell in love, means one avatar fell in love with another avatar, but in real world, she didn't like him. And in the last scene, it was shown that after knowing this truth, that the avatar is representing that person who is his friend working in the same company. Then she liked. So this is how the assets in the virtual world are created and how these can be protected. This is a big issue today before the intellectual property regime. Now, smart contract licensing. This can be one of the way. Excuse me. Revolutionizing IP management, automated enforcement. Smart contracts ensure automatic execution of license terms, eliminating manual processes and potential disputes. Payment splits are processed instantly, streamlining revenue distribution and ensuring timely compensation. Now, this will not only do this, whatever is in automated form, but it will also ensure transparency and tracking of all the records. Smart contracts provide a transparent and auditable record of uses, enabling accurate royalty calculations and ensuring compliance with license agreements. This level of automation simplifies IP management and reduces administrative burden. Now, how does a smart contract work? So a smart contract works like this format: identify agreement, set conditions, code business logic, encryption and blockchain technology, execution and processing, and network updates. So through this entire smart contract technology works where the safety and security of the user is protected. Now, global IP issues, a complex and ever-evolving landscape, cross-border challenges. The instant nature of digital content dissemination presents unique challenges for IP enforcement. Different countries have distinct IP laws, creating complexities in regulating and protecting IP rights across borders, as I have started this in the beginning with my lecture. Now, international enforcement in another issue. Enforcing IP rights across borders is a complex and resource-intensive process involving international cooperation and coordination between different legal systems. Effective enforcement requires a global approach and collaboration between stakeholders. Now, WIPO's digital initiatives shaping the future of IP. Adopting IP laws. International organizations like the World Intellectual Property Organization are actively adapting IP laws to address the unique challenges posed by the digital environment. This includes updating existing treaties and developing new agreements to address emerging issues. Many of the agreements we all know have been done and concluded finally in the area of intellectual property to address the issues or new challenges posed by several new things. Now, combating online piracy, WIPO plays a crucial role in facilitating global cooperation to combat online piracy and infringement of IP rights. This involves sharing best practices, coordinating enforcement efforts, and promoting awareness of IP protection in the digital realm. WIPO is actually under the TRIPS agreement, under an obligation, they had to do all this, and they are doing their means you can say job very good today to promote intellectual property rights at global level. Now, EU digital IP rules, a stringent approach. European Union has their own digital IP rules they have framed. So what they did, the EU has adopted a stringent digital copyright laws to protect the rights of creators and publishers. These laws addresses issues like unauthorized reproduction, distribution, and public performance of digital content. Similarly, platforms are required to proactively filter content to remove infringing materials. This approach aims to prevent the distribution of unauthorized content and ensures the protection of IP rights. So this is how European Union is trying to make a balance. Similarly, US digital IP law balancing innovation and protection. The Digital Millennium Copyright Act provides safe harbor provisions for online service providers, shielding them from liability for copyright infringement by users if they meet certain requirements. The fair use doctrine allows limited use of copyright material for purposes like criticism, commentary, and education. This principle balances IP protection with the need for freedom of expression. Asian digital IP diverse approaches and emerging trends. But in Asia, we have diverse approaches. Enforcement strategies in Asian countries adopt diverse enforcement strategies ranging from administrative measures to judicial proceedings to protect IP rights in the digital space. Online marketplace in Asia are subject to specific regulations, including requirements for due diligence, content moderation, and cooperation with IP rights holders. Similarly, cross-border enforcement mechanisms are increasingly being employed to address IP infringement originating in Asia. This involves collaboration between authorities and legal practitioners. So these are the trends which are developing in Asian countries, though in Asian countries we do not have any proper mechanism to resolve these issues like European Union has come up with the law or the US has come up with a different law. In India, of course, we have and recently we had passed digital rights, this Digital Personal Information Act also in 2023. Now, Indian perspective on IPR in the digital age. Legislative framework, India's Copyright Act, Patents Act, and IT Act addresses some digital IP challenges. Amendments needed to tackle AI, blockchain, and digital assets comprehensively, which has not yet been done. National IPR policy promotes innovation and IP awareness. Programs like Digital India aim to integrate technology with robust IP protection, which we are in process of doing. Challenges, lack of clarity on AI generated works and blockchain legality, enforcement struggles in combating piracy and cross-border IP issues. These are the challenges which are still left out in Indian legal system. So there are legislative requirements where the law needs to be amended according to the needs of the time. There are government initiatives nowadays also which are very much positive in nature, but still there are challenges left out before the Indian legal system and which needs to be addressed in near future. Now, emerging markets, a growing digital IP landscape. IP system development. Emerging markets are actively developing robust IP systems to support innovation and economic growth. These systems address the unique challenges of the digital age, including online distribution, digital content, and new technologies. Online enforcement. Emerging markets are enhancing their online enforcement capabilities to combat IP infringements and protect the rights of innovators. This involves investing in technology, training law enforcement officials, and building partnerships. And third is international cooperation. International cooperation is crucial for effective IP protection in emerging markets. This includes sharing best practices, providing technical assistance, and collaborating on enforcement efforts to combat cross-border infringements. Friends, for the development of IP system, even the emerging market forces are also very active. One of the best examples we can say is the FRAND terms, where if any patent is standard patent is in force and someone has used it or is willing to use it, which is raising lots of things, then the parameters have been fixed by those players themselves for the implementation of their standard patents. So you can remember the name friend terms and you can Google it and you will read the details. That is, I think, one of the initiative taken by the market forces themselves to combat the infringement of the and to balance the rights of the IP holders. Now, what are the future challenges adapting to emerging technologies? Quantum computing, as we all know, quantum computing is a very serious challenge which is going to take place. That AR and VR technologies and evolving AI technologies. I will not tell much details about these, but quantum computing is the fastest way of calculations, which we can say that it is going to means contribute a lot in the development of creation or innovations or new innovations. And in that case, machines will be enabled to create new technologies. That will surely pose the biggest challenge before the patent law. So that's a serious issue. Similarly, digital evidence and online dispute resolution, emerging solutions. Digital evidence is crucial for proving IP infringement in the digital age. This includes screenshots, hash values to verify file authenticity, and metadata to establish creation dates. So, who has created on which date for that digital evidence is very much important. And prior to the new Criminal Law Amendment Act, digital evidences were not recognized or were not admissible without a proper procedure has to be followed under the IT Act Section 65. And Section 65B certificate was required, which was a long procedure. But now it has been simplified under the new criminal law, and hash value can be taken of any digital evidence, and that can be produced in the court, and expert opinion is at all not required. Only expert certificate is sufficient. Previously, expert opinion was also required, and for that experts were called in the court. So that was actually a lengthy process of proving something before the court. But now it has been simplified. So digital evidence is the emerging solution. Then the second is online dispute resolution. Online dispute resolution platforms offer efficient and cost-effective solutions for resolving IP disputes. These platforms provide virtual courts, online mediation services, and automated systems to handle cases. Now, digital licensing, a new era. Automated systems, digital licensing platforms leverage automated systems with the help of NFT technology and the blockchain technology that leverage automated systems to track usage data. These systems provide real-time information on the extent and nature of IP uses, facilitating accurate royalty collection and enabling transparent accounting. Real-time royalty collection can also be done with the automated systems, and data-driven accuracy is also one of the areas and with the help of automated systems. Uses data collected by automated systems provide a rich source of information for understanding market trends and refining licensing strategies. This data-driven approach improves the accuracy of licensing agreements and facilitates informed decision making. The impact of open source on IP. Shifts in IP models. The rise of open source software has fundamentally altered traditional IP models. Open source projects rely on collaborative development and distribution, challenging the traditional notion of exclusive ownership and control over IP. Collaborative development. Open source fosters a collaborative environment, bringing together diverse communities of developers to contribute to shared projects. This collaborative development approach accelerates innovation and drives progress. Standardized licensing open source has led to the standardization of license, providing clear guidelines for using, modifying, and distributing software. These standardized licenses promote transparency and simplify the process of navigating open source. So this open source is also one of the best effort which is being made for the development and protection of the IP creation. Now, Creative Commons is another enabling open sharing, simplified sharing. Creative Commons license provides a standardized framework for sharing digital content, simplifying the process of granting permissions and promoting legal use. Author control. Creative Commons license allow authors to specify the specific rights they wish to grant, enabling them to choose how their work is shared and reused. The legal distribution. These licenses facilitate legal distribution of digital content, encouraging broader access and supporting a more open and collaborative digital environment. Now, patent pools, streamlining innovations. Patent pools facilitate the sharing of related patents, allowing companies to access a wider range of technologies and streamline licensing process. Patent pools are crucial for the development of industry standards that often requires multiple patents. They simplify the licensing process for companies implementing these standards. Now, by centralizing patent licensing, patent pools reduce the complexity and cost of negotiating multiple licenses, fostering a more efficient and accessible market. So patent pools are created where, for say, for example, a company wants to create a mobile handset, and for that, lots of patented technology is required. Now, negotiating with each and every patent holder is difficult and time-taking process and costly also. So patent pools are created where all the patents required for that particular product are available and negotiation time is also very less. So this is how this simplified procedure provide the access of patented technology with the simplest way with the use of technology. Now blockchain and patent protection. Blockchain technology offers new methods for securing and varying patents, enhancing the integrity and tamper-proof nature of patent records. Similarly, cryptocurrency innovation, the emergence of cryptocurrencies has driven innovation in blockchain technology, leading to new patent applications and protection for novel financial tools and protocols. Rapid financial evolution, blockchain technology is revolutionizing financial systems, leading to rapid advancement in digital currencies, decentralized finance, and other innovative financial tools, all of which require robust patent protection. Now, modern digital rights management. First is security and use. Modern digital right management systems strike a balance between content protection and user experience, ensuring that users can access digital content seamlessly while safeguarding IP rights. Second is enhanced experience. DRM systems are continuously evolving to enhance user experience, offering greater flexibility, user-friendly interface, and compatibility with a wider range of devices. Stronger protection, modern DRM systems employ advanced security measures to combat piracy and unauthorized access, ensuring that digital content is protected and IP rights are enforced. Now, platform responsibilities in the digital age, infringement prevention. So, first, the platform which is providing services, these are their responsibilities which they have to ensure for the protection of the digital content. Platforms have a responsibility to actively combat copyright infringement, adopting proactive measures to identify and remove unauthorized content. Then user rights, platforms must protect user rights by providing clear and transparent mechanisms for reporting copyright infringement and ensuring that legitimate users can access and utilize protected content. Then automated filtering, advanced technologies such as automated content filtering can help platforms effectively detect and remove infringing content, ensuring a safer and more responsible digital environment. Now, data rights and intellectual property rights. User control. Users should have control over their data with the right to access, modify, and delete their personal information. This principle is essential for upholding data privacy and user rights. So, from the perspective of users, this right must be given to the users. Second, data portability. Data portability allows users to move their personal information between different services, granting them greater control over their data and fostering a more competitive digital marketplace. Similarly, privacy laws are increasingly emphasizing data protection and user rights, impacting how IP is used and protected in the digital age. These laws limit the collection, use, and sharing of personal information, creating new challenges for IP holders when it comes in terms of digital content. Now, ethics in digital IP, a new frontier. Ethics is equally important because everything cannot be curtailed and controlled by the legal system. So, AI bias in creation, this is what we all know. There are reports which says that when it comes to the survey between, there was a survey conducted by a company for the doctors where the AI system, he has given a biased, means that AI system has given a biased data discriminating between the female this doctors and the male doctors. And when it was researched, the region which was found was that most of the times the names of the male doctors were referred. So female doctors' names were referred very less, and therefore the machine was biased. So at the time of creation of algorithm, these type of protections and means positive steps needs to be taken by the developers. Similarly, equal access to knowledge, ensuring equitable access to knowledge and information is crucial. Digital divides can limit individuals' ability to participate in innovation and contribute to advancement of intellectual property. Nowadays, many of the pseudo libraries has been created. That is also another emerging issue in the area of protection of intellectual property. And the reason is very simple because the access of the knowledge is very limited. So some of the internet libraries, they are providing free of cost that material for which or for the original content you have to pay. So to curtail, equal access should also be granted, and the law should do something for the equal access of the knowledge, which is which should be means made available to all. Now, industry's best practices, protecting your digital assets, comprehensive IP protection. Companies should establish robust IP protection strategies that encompasses all digital assets, including software, databases, and online content, because most of the times it is the companies who they are selling our personal data to others for generation of their revenue. So that has to be curtailed. Regular IP audits, conducting regular IP audits helps identify potential vulnerabilities and ensure that existing IP protection measures are effective and up to date. Employee training, educating staff about IP policies and procedures is essential to prevent unintentional infringement and promote responsible handlings of digital assets. Now, managing IP risks in a digital world. First, regular audit is required. Regular audits are essential for identifying and mitigating potential IP risks, including infringement, theft, or unauthorized use. Insurance is equally important. IP insurance provides financial protection against potential losses resulting from infringement, litigation, or other IP related risks. Then monitoring. Monitoring online activities for potential infringement or misuse of digital asset is crucial for proactive IP protection. Now, evolving landscape of IP rights, adapting to new realities. IP laws are constantly adapting to keep pace with technological advancement and the emergence of new forms of digital content. International harmonization, international cooperation is essential for ensuring consistency and clarity in IP protection across different jurisdictions. And then improved protection methods should also be applied for the protection of digital assets. New technologies and techniques are emerging to enhance IP protection, such as digital watermarking, encryption, and blockchain solutions. Now, what are the key recommendations which can be given? First, regular policy updates ensures that IP policies are regularly reviewed and updated to reflect evolving technologies and legal frameworks. Then technical protection, implement robust technical protection measures such as digital watermarking, encryption, and access control systems. Then active monitoring, active online monitoring activities and digital assets to detect and address potential infringement or unauthorized use. So these are the various recommendations which can be given for the protection of digital assets and digital technology. So thank you very much, friends. I hope I had tried to complete in time. Now, if any one of you does have any question or query in your mind, may please ask. Yeah.
All the participants are requested to unmute themselves and put their queries, or they can even use the chat box. Any question from the participants, please? So there are few questions. I think it is related to that old Raghav thing. It is like since Ankit is a lawyer, so is it maintainable? Does Ankit own the patent in the Raghav scenario, sir?
No, as I have told you, that see, creating AI and algorithm is a different thing. And something created with the help of AI is a different thing. So first thing I would like to make it clear that Raghav itself is not an invention within the strict definition or technical definition within the patent law of 1970. And therefore, that is not patentable. Neither the painting created by Raghav is patentable. I hope
Okay,
it is
sir.
clear.
I think it is clear, sir. Actually, that participant called me. She is unable to switch on her microphone and video cameras.
It's okay. It's okay. No issue. So please, I hope she might be.
Yes, yes. She has said it is okay, sir. She has expressed her satisfaction, sir.
Okay.
Anyone else who would like to raise any questions? Yes, you're audible, or your voice is coming little low.
Sir, can you please explain what is blockchain technology?
Okay, so she is asking what is blockchain technology, if any explanation.
See, thank you very much, Dipti madam. Actually, I'm also a person from the legal background, not from the computer sciences. So, in a basic understanding, what I have understood, because I may not be able to tell you technically the details of the blockchain technology entirely, as it can be done by a cyber expert. And I hope there was a lecture from one of the cyber experts. But what I have understood that, you see, you have seen the chain, no? So every chain has the small blocks, no? Now they are connected with each other, but they are independent in nature. So block technology is something like that, where every block is independent, connected with each other, but the information carried by that block is shared with other block but cannot be broken, because that is stored within that block. That does not pass. So a code is passed, and through codes the information is passed, and therefore it is unbreakable. That is what I have understood. I think you need to read its details.
So there is one more question.
Yes, please.
So this is asked by Kalpana Bharti. How can we trace whether our copyright material is being infringed through any AI tool?
That is what I said, that this is the biggest challenge. And for that, I have suggested some measures. But this is the biggest challenge. And if any copyrighted material, which is in digital form and is being infringed, it's very difficult to trace. So there may be some technologies, or maybe some technologies are being developed. But when it comes to the legal protection, law does not have any answer of this question.
So again, one issue is there. Just I am adding to it. Suppose when we copy some material content from the website, what it
Yes.
happens, it gets tracked through plagiarism tool, because copyright of expressions can be tracked. But when the same matter is typed in the form of a questions or description, chat GPT or any kind of AI bot gives an answer, then it is already paraphrased.
Mhm.
So then again, from which source, it is also not mentioned in the chat GPT. Most often, if you don't put the
Correct,
prompt to
correct,
mention
correct,
the references,
correct,
it becomes even more difficult, sir.
correct. So
Even if there is,
that is where the intellectual property laws are facing challenges. And that is why I said in the last of my presentation that not only the law, but the companies, the platforms, they should also try to evolve a robust management system through which it can be curved and it can be traced out whether there is any infringement or not. If there is, how to track that. So this is how the technology has to evolve. The companies providing, say for example, ChatGPT. ChatGPT does not provide you the source, but now the plagiarism check engines, they are having facility. They will tell whether this is a ChatGPT written material or it is a material written by a human. So that can be tracked up to some extent, because the finest language, I hope, I may be wrong, but I think that depends upon the language used by ChatGPT and the language used by a human or an individual. When an individual is writing something, there may be few people expert in a particular language. Otherwise, we used to commit some mistakes. Whenever we are writing a paragraph, we will surely commit some mistakes. But grammatical errors may not be there when it is written by some AI tools. So this is how I think nowadays plagiarism these checking engines are tracing whether the material is written by an individual or by a machine.
Another very important question, this is even going to be the biggest issue in the future days, that is how to prevent tampering of digital evidence through artificial intelligence.
See, I think the best answer of this can be provided by a cyber expert. I'm sorry, friends, as I came only to discuss about the legal part, but whatever I have understood, I think, say for example, recently in the criminal law, the hash value has been given an legal status importance, that whenever any digital evidence has to be produced, the hash value certificate has to be produced along with that. If the hash value remains same about any digital content, then it will be considered and admitted in the court. This is what the new criminal law says. Probably these type of technologies or these type of systems may be there in existence through which tampering can be checked, or in future they can be evolved. So I would request the organizers that since many of the participants, they had this type of queries in their mind when an expertise mind is required. So it would be better if you can organize one lecture from a cyber expert or a
So we
computer
have
software
one
engineer.
session tomorrow.
Yes, yes. So I hope, friends, these type of questions will surely be answered by tomorrow's lecture session.
Sir, one more question is there asking for explanation, but this is related to blockchain. Shall I read it out, sir?
Yeah, you can read. That will enhance my knowledge also.
Yes, sir. It says different blockchain networks often
Hmm.
cannot communicate with each other, creating silos and hindering the seamless exchange of information.
Mhm.
Practitioners need to address
Mhm.
inter I think it is typing mistake, interoperability
Mhm.
issues. Please explain, sir.
Yes, so I do agree with that, that if this exists there in the blockchain technology, then that has to be addressed by them. I have suggested this as an alternative for the protection of intellectual property assets, where through creating contracts, smart contracts, digital assets can be secured up to some extent, intellectual creativity. But when it comes to the specific technology, I think can be addressed if there are certain problems, and that can be means the best answer of this question can be provided by the cyber expert who knows about the blockchain technology details, or a computer programmer.
Okay, that's all, I suppose. So I'm again calling, if any participant has any question, they can please unmute themselves or type it in the chat box. Somebody is typing one more question. Let's
Yes,
wait.
yes, please.
Ramani ma'am, you can WhatsApp me the question. I am online in the WhatsApp. If you're finding it difficult to place it. Okay, it seems it is here.
Madam, your question is very much interesting and very good. Quantifying how much knowledge is required for a lawyer, telling anything about this, I think is very difficult for any person like me who is a teacher. I'm not a person practicing actively in the court, but yes, of course, with the whatever my little knowledge I had, I can say that obviously at least practitioners must have knowledge. And second thing, there are certain problems which are going to be faced very soon by the lawyers in the courts directly related with the digital evidence. And most of the peoples might be confused related with the provisions which have been introduced now. Say, for example, when any digital evidence has to be produced before the court, two certificates as per evidence law are required. One by the party wants that to be admitted, and other expert opinion. Now, this expert opinion thing is creating a lot of confusion in the minds of the advocates. Who is expert? Expert under section 39 of Evidence Act, who was providing certificate under 65B of the IT Act, or any other person. Now, if you go by old definition, many states they do not have that much that category of experts. Even states they do not have. So then, what type of expert it is required? Now, police is practicing; they are providing certificate through their cyber cells. So there are certain gray areas where an advocate, I think, needs to know, and they has to enhance their technical knowledge nowadays, because without that, it is going to be very difficult for the advocates to sustain in the court before the new generation, because new generation nowadays from very childhood they are very much expert in technology. So we also need to know. So I hope I have answered you, ma'am.
Any,
Okay, so I think
any,
yes, please. Anyone else?
any more questions? I think dear parties, sir, I think there are no more questions.
Okay, thank you.
Okay,
Yes,
sir. So that is all. I'd like to inform everyone that yesterday I called Mishra sir to give a genuine reminder, and then I was informed that he was 7 days in hospital due to certain infection, and it is very huge privilege for us that he, for this purpose only, for this session, for enlightening all of us, he took discharge in a situation where he was not allowed even. So it's a very big privilege for us that you have taken that much of hardship and you have delivered this much amount. I was really afraid. He is on liquid diet. He could not take any solid diet. Still, he has delivered for this much of amount. It's a very great honor for us, sir. So, so, sir, now I'd like to request our research scholar Krishna to please promote the vote of thanks formal to wind up the formalities.
Okay, sir. Thank you, sir. Sir, on behalf of Department of Law and all the participants, sir, knowing your condition just now, it is truly a great thing. We feel so honored to have you in this session, sir. We thank you on behalf of Department of Law, all the students of Central University of Karnataka, and all the participants, whoever has joined. Sir, your discussion over protection of intangible assets in connecting IPR with AI, discussing about AI and copyright challenges, blockchain technology basics, NFTs, which is very foreign topic for many of the participants as well as me being a research scholar. So you have conveyed from basics and discussed the intricacies involved in this subject topic. Sir, we are very much glad, and we hope you give us time like this in our future endeavors as well, sir. Thank you very much, sir.
Thank you. Thank you very much. Thank you.
And, we hope a fast recovery as well, sir.
Thank you. Thank you.
Thank you, sir.
Thank you, sir, once again, sir. Thank you. So request the participants to gather back at 1:55 p.m. for the next session, which is going to be on filing of patents.
Thank you all.